Well, 7:33, everybody. The legal fight over the abortion pill mifepristone is not over despite Friday's small victory. The Supreme Court issued a last-minute decision allowing women access to the pill while the case plays out in appeals court.
The next hearing on the case is scheduled for May 17th. So joining us this morning with a little bit of insight on what we can expect now is CUNY Law Professor Natalie Gomez-Velez. So good morning to you, Natalie. Thanks for being with us.
Good morning. Thank you for having me.
So this is the second time in less than a year that the abortion issue has come up before the Supreme Court. In your opinion, what does this indicate?
This indicates that contrary to some of the assurances that were made in the wake of the Dobbs decision, which was a decision focused on overturning 50-year precedent that held that the United States Constitution contained a fundamental right for women to decide to continue or terminate their pregnancies with some restrictions later in pregnancy, didn't end with that. This case involves an attack on basically the regulatory state. It's coming at it from the position of trying to overturn the FDA's expert judgment that misoprostol, the abortion pill, is safe and effective.
Yeah.
And so it continues a battle that some had thought would end with allowing the states to determine abortion restrictions on their own.
Right. So Natalie, I guess, can you help us break down what exactly Friday's Supreme Court decision means in terms of the case in Texas, right? Because there are different things here, and then the appeals court case, a lot of factors playing in.
Right. It's complicated, and I think it's complicated on purpose. A group of anti-choice, an organization of anti-choice doctors brought this case specifically in Texas so that it would get to this judge, Kaczmarek. He issued a startlingly lawless and political decision, basically ignoring bedrock principles of standing, timing, etc., to basically say that the FDA no longer had authority or did not have authority to approve mifepristone. That then was appealed right away to the Fifth Circuit. The Fifth Circuit, which should have thrown out the case on standing grounds, did not do that. It overturned a portion of the Texas judge's decision on the original approval, but upheld the decision with respect to later limitations that the FDA had since changed, right? So making it available 10 weeks, up to 10 weeks rather than 7 weeks, right? Pushed it back to 7 weeks. Making it available through telemedicine and through the mail, pushed that back. And making it requiring women to go to 3 doctor's visits in order to obtain the drug, pushed that back instead of 1. Right. And so the Biden administration then appealed to the Supreme Court seeking a stay. All of this is preliminary, seeking a stay, and achieved that stay on Friday, late on Friday. So the case is just in a holding pattern for the status quo. What would have happened would have been chaos with respect to the ability of the company to have the drug available in an approved way, or to require labeling and other things.
Yeah, I mean, that is a lot. It's a lot, Natalie. So you say confusing on purpose, but why?
So these are efforts to obstruct women's ability to get, not only abortion care, but reproductive health care more broadly. Remember, this drug is available for early pregnancy, right? If you to terminate an early pregnancy, what the drug does, you have misoprostol there, but mifepristone blocks the hormone progesterone early on, and it only goes up to 10 weeks of pregnancy. And then misoprostol induces the cramping. It's used not only for abortion, but in cases of miscarriage. It is safer and more effective in many instances than surgical abortion. So what they're doing by trying to block access to medical abortion in this way really harms women. And when you think of it in the context of the restrictions that many states have put in place to access to abortion care by providers in those states, by clinics in those states, it's designed to make it very difficult for women to access care.
So Natalie, what kind of implications does the case have then on states like New York, right, where the governor has said, hey, we're going to stockpile the drug, we're going to have plenty of it on hand? Are there implications for a state like New York?
So far, no, right? We still have access to the drug. Things are in a holding pattern status quo. The case, though, is proceeding, and as Hazel, you mentioned, it's going back to the Fifth Circuit. There are hearings scheduled for May 17th. The case will proceed. Now, hopefully, what will happen is it'll be dismissed in its entirety, and these restrictions won't be in place. But to your question, Dan, what happens in states like New York? Hopefully, there will be no implications for access to abortion, right? It depends, though. If the Fifth Circuit determinations on having to go to the doctor's office are upheld, having to, limiting to 7 weeks rather than 10, those may have implications for the availability and the access to the drugs nationwide. But so far, that's not the case. But here again, you've got this uncertainty that makes it very stressful for women seeking care, for doctors seeking guidance, and for even pharmaceutical companies seeking regulatory guidance.
So the holding pattern continues. Natalie Gomez-Velez, thanks again for sharing your insight with us this morning. We always appreciate you being on.